Well, good afternoon, everybody, and welcome to this edition of John's Rants. I'm John Giardinelli. I'm Association Counsel, and today we're going to talk about some things that are hot in the professional standards department. I wanted to bring your attention to a couple of issues that are very, very important for a lot of you, and hopefully will help you avoid getting into some trouble. The market is changing, pardon me, as we speak. And so there are probably going to be some new issues down the road. I know that the next time I do one of these rants, we're going to talk about trends in liability based on this new market. What kinds of things are we going to see? What might you need to be aware of? And so we'll do that the next time I record one of these rants. But for right now, I'd like to talk about a couple of topics that are really important for your professional standards and also for the way you do business. Number one, probably one of the most common phone calls the professional standards departments are getting has to do with signage. Remember, in California, in order to put up any sign anywhere, you have to have the permission of the property owner. That is California law, been in existence for a long time. So for example, to put a sign on anyone's property, whether it's for sale or coming soon, you have to have written permission from the property owner, and that is obtained through your listing agreement. But in the public rights of way, the local jurisdiction, whether it be the city or the county in unincorporated areas, are the property owner on behalf of the citizenry, and they can actually pass and do pass ordinances that deal with your signs. So I wanted to cover a couple of those issues because we've been talking to a couple of the cities and they're not happy. And if they get unhappy enough, there is nothing either legally or constitutionally that would prevent them from simply saying no more signs in the right of way. And there's a lot of jurisdictions that have those rules. So you wouldn't be able to put directional signs, open house signs, or any other type of sign in the public right of way. So it's very, very important that you understand these rules. So first off, I want to talk about the Department of Real Estate. Make sure that you go on to their website and take a look at what they require in terms of signs, the name of the brokerage, the license numbers, all of those kinds of things are really, really important, because if they see that your sign does not have the correct information, and I just went through this with a large brokerage that I represent, that they could cite you and fine you up to $2,500 per incident. And so you don't want to get in that situation, because if it becomes repetitive, they can actually issue an accusation, and that could affect your license. So there's if you go to the association's website under professional standards, we have written up some advertising guidelines. Now, I haven't updated them recently, but in August, we're going to update them. And so they'll be current, but they're, in terms of what kind of, what you have to put on your signs, that's all pretty current. I'm going to update the section on coming soon and some other stuff. So just be aware of that. Make sure that the proper name, the name of the brokerage, and the proper licensing is on your signs to avoid any DRE implications. Let's talk about some local ordinances, because again, if enough agents continue to misbehave, the city and or the county can simply say, fine, we are withdrawing or severely limiting the signs that can be placed in our public right of way. The kinds of complaints we're hearing from both members as well as from jurisdictions could impact everybody. For example, signs that are supposed to be taken down after an open house is done, or directional signs or something like that, are being left overnight or past the weekend. And so you need to know, before you start putting your signs up, what are the local jurisdiction rules, and then you need to make sure that you make plans to comply. Very, very important that you do that. Where to place signs in the public right of way. Some jurisdictions have very specific rules because of safety concerns or because of aesthetics, the clutter of all these signs. I know in Tennessee, for example, where I live, it's an election year and the clutter is just amazing of all the political signs. Now, they're not going to do anything regarding political signs because that has to do with their positions. However, for sale signs, directional signs, open house signs, that is something that they may act upon. So be aware of the limitation on the number of signs because of clutter and safety issues. Also, you need to become familiar with what are the rules for sale signs. Specifically, what are the rules for directional signs? Again, you need to make sure that wherever you put those, whoever owns the property has got to give you permission to do that. And then the one that seems to cause a lot of difficulty now that we're back to open houses again are the open house signs. And you need to be very careful that you understand that if you do have an open house and this jurisdiction allows you to put up for the signs regarding those, including directional or off-site property signs, that means you still need to comply with the rules regarding the signs, the balloons, and all that kind of stuff. Another issue that comes up in signs is you need to make sure you understand what the rules are for teams and the proper team designation. Again, it's critically important. If you take a look at the article that's on the association's website regarding advertising guidelines, we have a whole section in there on all of the various rules if you're advertising as a team. Another issue that's been coming up has nothing to do with open houses or for sale, but there's signs that are put up that basically are small billboards that advertise services or that simply talk about you as an agent or a brokerage. And again, there are severe limitations for being able to do that. And then overall, everything else, you also need to understand that under both Department of Real Estate rules and under the Article 12 of the Code of Ethics, that your advertising needs to be truthful and it needs to be accurate. So again, those are very, very important signage issues. The California Association of Realtors does a really good job. There's a number of papers on the CAR website. If you navigate through and look for signs and Q&As and legal papers on signs, gives you a lot of really good detailed information. Another issue that seems to be coming up a lot is the misuse of public remarks in the MLS. I did a program day before yesterday with Ed Zorn, who's the attorney for CRMLS, and the misuse of public remarks seems to be a heavily cited issue. Members will put something in, they'll be given a warning to fix it. They don't fix it, they're issued a citation, and now you're paying a fine. So again, remember, the purpose of public remarks is not to advertise your brokerage or to advertise your services. It is to provide information about the property in question. Remember, the multiple listing service is not a place for you to advertise to the general public. It is a place where you provide information to other subscribers and participants of the multiple listing service and the reciprocal multiple listing services that involve issues relating to the house you are trying to sell or rent. So regarding issues regarding open houses, putting up photographs of your company sign, which of course means that your phone number and all that is available to the public. All of those things is a violation and could get you a pretty substantial fine. Again, remember, the purpose of an MLS is to cooperate and then to offer compensation to anyone who brings you a ready, willing, and able buyer. Another issue that seems to be coming up in the MLS a lot, and it's constantly an issue that the attorneys at CRMLS will talk about, and that is misuse of photos or videos. Remember, if you hire a photographer, and CRMLS has a list of photographers that have agreed in writing to follow their rules and their procedures, but if you hire a photographer, you're being given permission to use that photographer's work for a fee in order to place the photos in the MLS, in brochures. Other agents are entitled to use those photographs for the limited purpose of advertising your property in the manners set forth in the rules, but it is not to be able to use other people's photography or videos for other purposes. For example, if the listing expires, doesn't give you the authority to go in and use the photos from the prior agent. It only allows you to use the photos that you have hired. And if you fail to comply with those rules, the fine without warning is going to be $1,500. And so it's cheaper and certainly less cumbersome for you to comply with the rules, because that $1,500 is only the MLS's fine. It has nothing to do with what the photographer whose product you are misusing can bring against you. So be very, very careful that you have written consent, that you've paid the proper fees if necessary, that you follow all the rules. Otherwise, you could be hit without warning for a $1,500 fine. Another issue is coming soon signs. Remember, coming soon is an off-market category or status. Therefore, you've got to be careful. Showings are extremely limited, and for the most part is a violation if you set up showings. If you are going to start showing property or do other things to market the property, remember that then requires you to flip that status to active within 1 business day. So it's very, very important, excuse me, 1 calendar day, that you do that and that you comply with those rules. Again, the fines can vary anywhere between $500 and $2,500 for violations of coming soons. Another issue that comes up a lot is the issue of negotiating your commission through the offer and or the counteroffer. It is a violation of the Code of Ethics to write up an offer, and in that offer indicate that you would like to be paid more commission that is being offered in the multiple listing service. It is also a violation of the Code of Ethics, and with fines as high as $15,000 if you use the counteroffer for that purpose. In other words, we'll accept your offer conditioned upon you being willing to accept less commission. That is a violation of the MLS, excuse me, the Code of Ethics. It's not in the MLS, and of course, always keep in mind whenever you're talking about your commission, that your commission is secondary to the duties that you owe to your client. You have fiduciary obligations to your client, and negotiating your commission without the client's full understanding is not necessarily the right thing to do, and could get you into some trouble, not just with the board, but with the Department of Real Estate. Always remember that if you're going to negotiate commission that is different than what is in the MLS, on either side, either a seller trying to lower the commission or a buyer trying to get more money, that you can do that. You have to use the cooperating broker compensation form, probably have a phone call with the other broker. The broker has to consent, even if it's being negotiated between 2 agents, and you put that in writing, and you always let your client know what's going on. Another hot topic that's been coming up lately has nothing to do with professional standards necessarily, but are your websites. I'm not going to go into it in great detail today. I'm probably going to spend a significant amount of time at the next rant talking about website compliance. You guys need to understand that your website is an extension of your office, and therefore under both the UNRRA Civil Rights Act and under the Fair Housing and Employment Law, you must provide accommodation to people that are disabled, usually in the context of a website, to someone who is either hearing and or sight impaired or blind. And so there are very specific rules, there are very specific standards for how your website needs to be set up, and you need to make sure that you talk to your IT people and make sure that they are fully aware and have done everything they can to comply with the ADA laws. It was interesting that we had the deputy commissioner at a fair housing panel recently, and he pointed out that statistically, disability claims are actually twice the number that are filed on race-based discrimination. You would think that with all the news coverage and all of the conversation about racism and about race, that race would be the number one, excuse me, the number one discrimination claim, but by almost a 3-to-1 ratio, ADA claims are greater. One of the things I think that's going to start coming up a lot is with less transactions and other types of issues, that you're going to see more are claims regarding people stealing other people's listings and other people's buyers. And so you should be aware that the association has an arbitration service. It's going to be an arbitration amongst your peers, but even better is the association has an outstanding mediation service available to members and clients of members. It's cheaper, it's more speedy, you can do it faster but for a lot less money. These are trained mediators. They've been through the various training programs. Some of them are lawyers, some of them are brokers with years of experience who have gone through mediation training to try and get your claims settled. Their mediation is perfect for issues relating to deposits, for issues relating to possession, and not getting stuff out quick enough, minor disclosure issues, or even major disclosure issues. Know that in your in both your listing and in the RPA, there are mandatory rules that can have a huge impact on a dispute where mediation must be agreed to if offered. So again, when you think about what it costs today to litigate, even to arbitrate, the cost to mediate is far, far greater. And the association has a outstanding mediation program that you may want to take a look at for either you and or for your clients that get involved in a dispute. A lot of cases settle at mediation, and it is a very, very good thing. So again, the next time we get together, we're going to talk about some forms, what's happening at CAR with the RPA, and how they're going to clean it up in December. Also, some changes that'll probably be taking place to the buyer broker representation forms. We're going to be taking a look at some market-driven issues regarding liability trends and some things of that nature. So if you have a particular issue or topic you want me to cover, let Lori Smith know, in the professional standards department. She'll let me know. She and I get together before every one of these ramps. We go over what are the hot topics in the association, calls she's getting in the RED program, and so forth. And we'll talk, and we will provide some solutions for you guys to the best of our ability. So until the next time, this is John Giardinelli, Association Counsel, signing off and thanking you for watching John's Rants.